Hola, buenas tardes. Sean bienvenidos al tercer Festival Internacional de la Secretaría de Cooperación Internacional y de la Facultad de Contaduría y Administración. El día de hoy nos acompaña la UNAM Canadá y cedemos la palabra a Gerardo Familiar, quien es secretario de la sede de la UNAM Canadá, quien nos va a apoyar con esta presentación y a moderar este evento.
Thank you very much, Rodolfo. Thank you very much for this opportunity. We're going to switch to English now because the talk today will be in English. I would like to start by thanking the Facultad de Contaduría y Administración for this invitation, and of course our two presenters tonight. First of all, we have Doctora Hepzibah Muñoz Martinez. She's a professor in the Department of History and Politics at the University of New Brunswick campus, St. John. She obtained her bachelor's degree in international studies from Universidad de Monterrey and master's and PhD degree in political science with a focus on political economy from York University, Canada. Some of her publications include the book Uneven Landscapes of Violence, Geographies of Law and Accumulation in Mexico, published in 2021, Between the Washington Post, Washington and Wall Street Consensus in the COVID Era, the Mexican Case, which appeared in Studies in Political Economy in 2022. Navigating the Aftermath of Crisis and Risk in Mexico and Turkey in Research in Political Economy in 2016, co-authored with Thomas Marois. Hedging Neoliberalism in Mexico, Derivatives as State Policy, New Political Economy, 2015. The Depoliticization of Trade in the North American Region, International Journal of Political Economy, 2014, co-authored with Stephen McBride. Also tonight we have Octavio Israel Torres Lopez. He's a Mexican attorney from the law school at the Universidad Nacional Autónoma de México. He also holds a master's in international law from the Instituto Tecnológico y de Estudios Superiores de Monterrey, and a master's of arts in political science at the University of New Brunswick in Canada. He has more than 15 years of experience in Mexican public administration, including his work from 2005 to 2010 for the Mexican Ministry of Economy in the negotiations of bilateral investment treaties, BITs, and investment chapters of FTAs. He also represented Mexico before the Investment Committee Bureau of the Organization for Economic Cooperation and Development. He operated the national contact point of this organization to foster corporate social responsibility, including mediating bona fide agreements on controversies involving transnational corporations. UNAM Canada is very happy to have you both, and without further ado, I pass the floor to both of you.
Well, I want to thank you for the invitation. It's an honor to be here, and I hope that this knowledge is useful for your future careers and also for those academics in attending this event, that we can exchange some interesting ideas. So today we're going to be talking about CUSMA. That's how it's called in Canada, Canada-US-Mexico Agreement, which we call TEMEC. So we're going to talk about the relationship between CUSMA, regulatory harmonization, and policy, especially public policy, focusing on the Canadian case. So what do we mean by regulatory harmonization? So we have to make a differentiation between regulatory cooperation and the regulatory harmonization in terms of good practices that are included in Chapter 28 within CUSMA. So regulatory cooperation is going to be more about consultations between regulators from different countries to discuss ways to eliminate differences between their countries' regulations. That regulatory cooperation can also refer to equivalency agreements. That means that that's where two countries agree to accept each other's regulations and enforcements as equivalent despite their different systems. And this regulatory cooperation can be informal and voluntary, or structured within international agreements. So this is something that you can see already for those that are accountants, that is encouraging international accounting practices, for instance, or banking regulations, for instance, the Basel Agreement. Whereas what we're looking at is, let's say, a more profound form of regulatory cooperation within regulatory harmonization, especially the one that we see in the good practices chapter of 28, chapter 28 in CUSMA. So basically, this is going to be more strict in terms of what information and studies might be used to develop domestic regulations, how other countries should be involved in the rulemaking process, and what are the types of procedures that are needed for adopting and reviewing and repealing regulations. So it's a deeper form of regulatory cooperation that also involves direct sanctions. And it's also based on standard setting that looks at risk issues according to the actors that negotiated this agreement. So here we have that chapter 28, the good regulatory practices chapter in CUSMA, and chapter 31 are related. So here we have that CUSMA asks each country to set a procedure where businesses can petition an agency to repeal or modify a domestic regulation because it's burdensome than necessary and to achieve its objective, right? So if regulators agree to lower harmonization standard, then the stronger standard in this agreement between regulators then is repealed. If it's not repealed, this could be a factor for a legal challenge brought by affected industries in domestic courts. If that doesn't change the regulation, repeal the higher standard regulation, then what we have is the use of chapter 28 to launch a state-to-state dispute settlement within chapter 31. And failure to comply with this means tariff sanctions by the other member states. So what is our argument? Our argument is that chapter 28 shows how now the new NAFTA is not so much about trade and investment. It still is, but it's not the only thing that is central to it, but it's also about direct regulatory harmonization, which not only affects trade and investment, but all areas of public policy and economy, even our issues like food safety, for instance. But then, so we have to raise a question, or what we do in our research is to raise a question, well, who's harmonization? Who participates in the making of it? And why is the Canadian case more complex in terms of public policy? So, I mean, so regulatory harmonization, we already see it, for instance, in the labor and environmental chapter. The chapter 23 within CUSMA has to do with labor. The chapter 24 within CUSMA has to do with the environment. And basically, what these chapters try to do is to make sure that no country within CUSMA can use lowering of environmental and labor standards in order to gain a competitive advantage for investment, to attract more investment. But this type of regulatory harmonization, however, has been in the making in the long term. And it has to do with very grassroots mobilization in the three countries regarding labor, particularly the role of unions and labor organizations, as well as the role of environmental organizations. I'm going to go back to this point later on, but interestingly, chapter 24, the one on the environment, only covers 7 multilateral agreements. When these chapters, if failure to comply with these chapters takes place, then a member party in CUSMA can launch a state-to-state dispute within chapter 31st. However, that might not be the same story of regulatory harmonization in relation to chapter 28. And it's chapter 28 in a way is more of a could be considered a continuation of chapter 11, which Octavio is going to be talking to us about. But we also want to make the Mexican case a point of reference, because it's interesting to make a comparison between Canada and Mexico, especially in relation to regulatory harmonization, which has already happened indirectly. So for instance, we have chapter 11, where a lot of country was sued several times for tantamount expropriation. But in this case, the country, in this case, the Mexican state or the subnational units, could choose to retain that legislation that was considered tantamount to expropriation, for instance. But indirectly, they were forced to repeal it in order not to have future lawsuits. Also, in the case of Mexico, we have a more informal or formal centralized federalism. There's always the role of the federal government in, whether through coercion or cooperation, saying to the Mexican states, okay, please comply with, let's harmonize this to some national legislations, especially in relation to the economy, to international trade agreements, because otherwise there might be good things for you or bad things for you happen. And the other interesting about the Mexican case in comparison to the Canadian case is that international agreements in Mexico have a constitutional ranking.
Now, what we want to show here as part of this presentation is precisely the contrast, taking as a point of reference Mexico, but now focusing what regulatory harmonization implies for Canada. And I would like to begin the Canadian case by sharing how federalism works in Canada. In the Canadian case, federalism is decentralized. That means that some specific powers are directly granted to federal powers, to federal authorities, and some others to provinces. That means that in the case of international trade policy, federal authorities hold the power to negotiate free trade agreements. On the other hand, the implementation and the jurisdictional power in other areas belongs exclusively to provinces. That means that in the case of Canada, international trade agreements do not have a constitutional ranking, and provinces are not obligated to implement international trade agreements. This structure was established since the Confederation of this country in the year 1867. Since the very beginning, this division was established, and there are areas, as I'm sure you can read it there, as labor and environmental regulation that directly belongs to provincial powers, not the federal authority per se. So that means that Canada becomes a more complex situation when we talk about the argument that was earlier presented. Whose harmonization and who benefits from this harmonization? So to talk a little bit more about that, what we are showing you in the next slide, it's the reference of precisely some investor-state dispute agreements that, as we all know, they were accorded in Chapter 11 of NAFTA. As all of you may know, CUSMA erased or eliminated the investor-state dispute mechanism between Canada and the United States. That means that any foreign investor or international corporation does no longer hold the right to sue the Canadian state under the investor-state dispute settlement mechanism. However, let's start to see how this harmonization has worked from the beginning of NAFTA. I am just, because of a matter of time, I am just going to highlight two cases. The first one, which is Mobile Investments Canada, Inc. and Murphy Oil Corporation. And below that, you can see Mobile Investments Canada, Inc. That means that it is the same dispute brought by the same investors at two different moments. Interestingly, as we were saying earlier, the areas of environmental protection, natural resources are under jurisdictional powers of the provinces here in Canada. And the cases that are shown there are precisely in those areas. So that means that there is this situation between the conflict of an international trade agreement and the power of a province to regulate autonomously according to what is established in the Canadian Constitution. So let's talk about the first case. The first dispute was brought by a US corporation because in the year 2007, the dispute started earlier. In the year 2004, the Petroleum Board of Newfoundland and Labrador adopted the guidelines on research and development. These were considered performance requirements, and that meant that it required operators of offshore petroleum projects to allocate a specific percentage of their revenue to research and development, as well as education and training initiatives within the province. The international investors decided these requirements were breaching NAFTA stipulations. They started an international arbitral dispute. They won. However, the province did not remove those regulations, again, because the province was exercising or using its jurisdictional provincial power to regulate autonomously. So in the year 2014, the dispute was brought again by the same investors, and of course, they were awarded compensation because the performance requirements were considered to be inconsistent. I'm sorry if there's a sound, it's something on my phone, but I hope I'm going to continue, and I hope everyone can still hear me well. The next case that I want to talk about with you and share is the Abitibi-Bowater case. In this case, Abitibi-Bowater, also a US corporation, involved the bankrupt of a large corporation that closed its timber mill in Newfoundland and Labrador, leaving unpaid bills, unemployed workers, unhonored pension obligations, and contaminated industrial sites. The province, in order to clean up the site that was abandoned because of the bankruptcy of the corporation, seized the company's assets. Even though the company was already in bankruptcy, they decided to start an arbitration because of expropriation of their assets. So again, the award favored the international corporation, and of course pushed for this indirect regulatory harmonization, because what it showed, it was somehow a lesson for other provinces if they at some point were thinking or wanted to attempt for a similar stipulation. And the third case that I want to share with you as part of this research and the findings that we had is, as I mentioned earlier, CUSMA no longer stipulates or does no longer allow international investors to sue the Canadian state. However, CUSMA integrates what is called the CUSMA legacy clause. That means that after NAFTA concluded in the year 2020, any foreign investor still had the right to use NAFTA stipulations to sue the Canadian state. And that was for 3 more years. That was until July of this year, precisely. After July of this year, there is no large corporation allowed to sue the Canadian state. So the first legacy clause used in CUSMA was against Canada, and it was by this corporation called Koch Industries. The context of this dispute is that each province has programs and regulations for carbon pollution to design their pricing system according to local needs. In the year 2017, Ontario started a cap and trade regulation program consisting of a market-based system that set a hard cap on greenhouse gas emissions while giving flexibility and allowing businesses to buy or sell carbon credits. So in 2018, the Ontario cap and trade program was canceled, prohibiting emission allowances trading. The measure allegedly affected this U.S. corporation who opposed its cancellation, and it started an arbitration. What we want, it is relevant to mention here that this case is still active. There has no decision been issued yet, but it is again covering regulation that is under provincial jurisdiction. That means in the context of environmental protection and natural resources. We also want to share with you the findings about another case study here precisely in the province of New Brunswick. And this is related to the dairy industry. As part of this case study, we had the opportunity to interview government officials. As part of this research, we are not allowed to disclose the identity of this government official. So I always say, if you would like to find out a bit more, you can go to my LinkedIn and you will see who were the participants of these interviews, but we cannot say names. All I can say is that they are involved in international trade policy, and they gave us very interesting insights about what is happening regarding this harmonization in the context of CUSMA. So to begin with, it is relevant to say that the dairy sector in Canada operates under a supply management system based on production quotas, administered pricing schemes, and product import tariffs. The supply management is a means to regulate pricing and ensure stable revenue, setting the national quantity of milk produced at the federal level. So that means that the total fluid of fresh milk production quota is allocated to the provinces based on their provincial population, and the share is non-negotiable. However, in CUSMA, there were concessions that were provided to CUSMA counterparts. And because the concessions were against the supply management system established in Canada, compensation was offered to dairy farmers because of this harmonization of the systems. And in this case, of course, as we have been mentioning, it's a harmonization following international trends. Despite this concession and opening the market to dairy farmers and dairy products, Canada holds tariff rate quotas. That means that up to a certain level, that in importing dairy products, the tariff got a lot higher because the idea is to prevent a disruption in the market in Canada. Actually, because of this tariff rate quotas that Canada follows, the first Chapter 31 state-to-state dispute that was brought in the history of CUSMA was against Canada and again under the dairy industry. U.S. Dairy farmers stated that they were not allowed to access the Canadian market, but not as dairy farmers. This was involving dairy processors. That means those who are involved in producing milk powder, yogurt, cream, ice cream. An arbitral tribunal was integrated, and the International Arbitral Tribunal decided that Canada had the right to hold its tariff rate quotas, but what was inconsistent with CUSMA and with Canada's international obligations was the procedure to establish these quotas. That means a federal law in Canada was not in compliance, according to the arbitral tribunal, with the international obligation. And as a consequence, now Canada has to open the market to dairy processors. And also the federal authorities now are providing compensations to dairy processors. But as a consequence, we see as part of this analysis again, CUSMA is pushing for a regulatory harmonization. We wanted to share this quote as part of this research that is very impactful about how dairy farmers are affected in Canada. I am going to read it for everyone. It says, I now want to touch on the compensation package promised. So because there is my screen, sorry. Package promised and partly delivered for CETA and CPTPP. I haven't heard anything about the remaining years and how it will be paid out. That in itself concerns me. The compensation package is bittersweet. Most farmers, including me, received the payment in December of last year for those previous trade agreement concessions. As far as I'm aware, no concrete timeline has been set for the next payments. We as dairy farmers have always prided ourselves on getting all our money from the marketplace. This is how the system is supposed to work. This is how it did work. The government trading away excess and then offering compensation is not what we want. And finally, we also want to share another analysis from part of this case study, which is related to the procurement. Again, procurement is under provincial jurisdictions, and is, as I mentioned earlier, Canadian provinces are not obligated to follow international trade agreements. So for that reason, when NAFTA was negotiated, provinces were exempted in government procurement from the chapter. And when CUSMA was negotiated years later, the whole government procurement system is accepted from CUSMA because Canada and the United States follow the regulations of the government procurement agreement from the World Trade Organization, which includes federal, provincial, and municipal procurement acts. This, the World Trade Organization follows the negative list approach, which means that provinces and municipalities in Canada can express their exemptions to the access in government procurement. However, and as part of these dialogues that we have been constantly having with government officials here in the province, it is raising a concern because the province has this autonomy to regulate on government procurement, but because of the existence of all this, what we call the spaghetti bowl of free trade agreements and the regulations of the World Trade Organization, is somehow in contrast with the provincial autonomy in government procurement. And as a consequence, it is very likely, because of the way we see how this is advancing, that it will push for a regulatory harmonization. Thank you very much.
Sorry, I'm just, so in the next slide, we just wanna mention that, well, all these cases in terms of the dairy sector and procurement services, indirectly or directly, have to do with that regulatory harmonization that Chapter 28 kind of encourages and promotes. And also, it would be interesting to raise questions about to what extent, for instance, the Chapter 28 is going to undermine the efforts that have been put into, for instance, the environmental chapter. So, and that's because the environmental chapter only deters the lowering of regulations only in 7 multilateral agreements, which include the Convention on International Trade in Endangered Species of Wild Fauna, the Montreal Protocol on Substances that deplete the ozone layer, the International Convention for the Prevention of Pollution from Ships, etc. So, however, there are other sectors that are left outside of the environmental chapter, in which chapter 28 can be used to say, well, you cannot impose an environmental regulation on chemical usage or water allocation in bulk or fracking or softwood lumber, because that goes against what we agreed on chapter 28, especially if the lowest common denominator is, let's say, get rid of moratoriums or restrictions of fracking. So some concluding remarks here is that, well, the case of Canada shows clearly how CUSMA is not about trade, but also regulatory harmonization. So we need to ask the question, who's regulatory harmonization, whom benefits, right? Because in some cases, for instance, in the case of food safety, science is defined, or the necessary studies to make food regulation can be defined in ways that can shield corporate information needed to regulate effectively. Also, there's a limit on precautionary approaches on regulation based on locally specific context, as for instance, in the case of the dairy sector, there is a story behind the supply management system that had to do with particular needs of dairy farmers in Canada. And the arbitration panel said, no, it has to meet these other rules as standards that are particularly set by to match the United States way of producing dairy products. And there's also the potential of strong pressure to harmonize standards down to the lowest denominator. So in terms of more specifically on business, investment management, and accounting decision making, then, especially if you wanna want to work, or you want to really explore that part of investment in Canada, or if you get to work in Canada or research Canada, well, trying to understand what are the implications of investment and how that's going to relate to free trade agreements and provincial jurisdiction is a complicated matter that you need to be aware of. And the other issue here is that, CUSMA, in particular chapter 28, is going to have very important implications on Canadian provinces and even territories. So I mentioned territories because they're usually autonomous areas that of Indigenous communities in Canada. So it's going to have particular implications, especially on small provinces without very powerful national economic sectors. And there is an Indigenous general exemption within CUSMA that only relates to Canada. However, chapter 28 and chapter 31 can also be used to challenge those Indigenous and general exceptions. Because, if another country launches a lawsuit against Canada, we don't know about the composition of the arbitration panel, if they have expertise on Indigenous issues. And also there's a limited participatory rights of affected Indigenous parties. And basically there's an ambiguous clause in CUSMA within the Indigenous general exception that says the measure must not be used as means of arbitrary or justified discrimination against persons of the other parties, or as disguised restriction on trade in goods, services, and investments. So that's another thing concerning as well. But so one of the things that we have to keep in mind is that, especially when dealing with Canada, we always have to also consider the centralized federalism and its relationship to public policy, investment policy, and international free trade agreements such as CUSMA. Thank you. That's all.
Thank you very much. Sorry about that.
Yes.
Yeah, thank you very much, Hepzibah. Thank you very much, Octavio, for this very, very interesting overview about some very, very important differences between the Mexican and Canadian states. I also found very interesting your idea of maybe we should start calling these multilateral agreements regulatory harmonization agreements rather than trade agreements. This is a very, very interesting idea. And I would like to ask Rodolfo if there are some someone who would like to ask some questions, or what else do we have organized for tonight?
Yes, we have two questions. The first, what kind of social challenges, pros and cons, have arisen with this trade between countries?
Can you repeat the last part, please?
What kind of social challenges, pros and cons, have arisen with these trades between countries?
Do you want to ask the second question too? So we can.
And the second question, what makes Canada so attractive to investors from North America?
I'm gonna start with the second question. That's kind of more the area of expertise. I'm gonna leave Octavio the first question. Yeah, no, in the case of Canada right now, it's very complicated because right now, on the one hand, there's a real estate bubble that is putting the banks at the brink of a very difficult situation. And but on the other hand, Canada has it's so rich in natural resources. That's kind of one of the main financial services, and natural resources are the main sources of income. And if you, or probably you already know this, but the Toronto Stock Exchange is the main stock exchange of global mining companies in the world. So that's where most of the global mining companies raise their funds through stocks and bonds. So that's another reason why Canada is so attractive. And also this degree of certainty that even if taxes are high, etc., you already know that there are certain rules that have to be followed, and that there is, let's say, the protection of contracts and private property.
Thank you.
Heps, may I? Okay, you're done. Thank you. Well, first, thank you for the questions. That means that it raised this interest on participants, and they are very good questions. Regarding precisely what are these social challenges that have been brought by these trade agreements between countries, I would like first to, of course, focus in Canada, because as it was already mentioned, this study is based on Canada, right? So precisely those social challenges is what we just saw in the presentation. That means this environmental protection that somehow, as Dr. Munoz Martinez was saying, right, we know that in chapter 24, we have these 7 multilateral environmental agreements that the 3 CUSMA countries have to follow. They have to align all their policies. And then comes this question that we have been asked a lot, like, yeah, but what if harmonization is good? What is wrong with harmonization, right? So here comes this fine line between, far beyond saying it's good or bad, is what are the social implications? When we talk precisely about, in the case of the environmental chapter, that as we all know, Canada is very concerned about environmental matters. If the chapter 24 has no coverage and no protection for the use of chemicals, water allocation in bulk, environmental performance requirement, like precisely the investor dispute settlement mechanisms have shown, and as it was also mentioned, the case of fracking, that some provinces allow fracking while others don't. And here is when this regulatory harmonization comes in play. And also the softwood lumber, which is a historical dispute and a matter of a lot of interest that has lasted for years between the US and Canada. So the social implications is precisely what is not covered in that regulatory harmonization. And again, the question of, and that's why I think it's a very good question, because it comes down to the point of this presentation: whose harmonization to benefit who, right? So those are the social implications. And very brief, I don't want to talk about Mexico because, again, the research is not based on Mexico, but it would be something similar to, say, in the case of the labor chapter, right? And all the implications that it's having in the social aspects. But again, I want to go back to the main focus of our study. Thank you for the question.
Thank you. On behalf of Tomás Rubio Pérez, our director, and Mitzi Gómez Morales, the head of International Affairs Office, we end this conference by thanking you for your participation. Thank you, Israel, Hepzibah, and Gerardo.
And thank you also from UNAM Canada, and thank you to University of New Brunswick, Campus St. John, and Hepzibah and Israel for for sharing these thoughts and your ideas about your cases, your study cases. Thank you very much.
Thank you.
Pues nuevamente, muchas gracias, Hepzibah, Israel, Octavio, perdón. Ya nos confirmaron que ya salimos de la transmisión.
Ok.
Fue un placer escucharlos, verdaderamente qué ideas tan interesantes. Y
No.
bueno, pues mantengamos el canal de comunicación. Estoy seguro que vamos a tener muchas más oportunidades de continuar con esta colaboración, particularmente con la facultad. Es una facultad muy dedicada hacia la proyección internacional. Por eso es que nos animamos a pedirles que hoy presentaran en inglés y siempre están en búsqueda de oportunidades de internacionalización, tanto los estudiantes como los académicos. Así que exploremos más posibilidades, por favor, si les parece bien.
Sí, te mando la, y te